1997, when I repatriated to Cyprus, having grown up in Australia and having been researching anti-corruption for 30 years, I advocated the establishment of an independent commission against corruption in Cyprus. In 2013, in the anti-corruption manifestation prepared for the then newly elected president, again, a suggestion was made that an ICAC should be established. In 2015, having visited ICAC in Hong Kong and New South Wales in Australia, I prepared a detailed report of the aim, structure, and the budget of an ICAC. 7 years later, we now have an ICAC. And as Kavafi said, it is all about the proto skali, the first step. So the Honourable Mr. Haris Boyiadjis, Transparency Commissioner of the Independent Commission Against Corruption, will give us a keynote speech. Can I just kindly ask you? Perhaps you can also share with us some of the challenges you and your agency have faced. Thank you.
Thank you. I will make my speech in Greek. Do they have translation services? So?
Yes.
Yes? Okay.
Γιατί μας είπα μας αγγλικά.
Έχω τιτλοφορήσει την ομιλία μου «Αρμοδιότητες και εξουσίες της Ανεξάρτητης Αρχής κατά της Διαφθοράς», αρχίζοντας με τη σύσταση της Αρχής κατά της Διαφθοράς. Ο νόμος που προνοεί για τη σύσταση και λειτουργία της Ανεξάρτητης Αρχής κατά της Διαφθοράς στην Κύπρο ψηφίστηκε και τέθηκε σε ισχύ τον Μάρτιο του 2022. Ο διορισμός των μελών της Αρχής έγινε τον Ιούλιο του 2022. Η κατάθεση του νομοσχεδίου στη Βουλή είχε γίνει τον Μάρτιο του 2019. Αυτό σημαίνει ότι για 3 έτη υπήρχαν συζητήσεις για τη μορφή που έπρεπε να είχε λάβει η Ανεξάρτητη Αρχή κατά της Διαφθοράς. Βασικό θέμα ήταν οι εξουσίες της και κατά πόσο δηλαδή αυτή θα έπρεπε να έχει ανακριτικές ή ερευνητικές εξουσίες. Παρόλο ότι οι συζητήσεις αυτές γίνονταν προφανώς πριν το διορισμό των μελών, εμάς ως μελών, πληροφορηθήκαμε αργότερα ότι αποτελούσε θέση του Παγκύπριου Δικηγορικού Συλλόγου ότι η αρχή θα έπρεπε να έχει ανακριτικές εξουσίες. Την ίδια θέση είχαν και οι οικολόγοι, οι οποίοι 3 μήνες μετά το διορισμό των μελών της αρχής, ήδη το Σεπτέμβριο του 2022, από ό,τι έχω πληροφορηθεί, κατέθεσαν σχετική πρόταση νόμου, την οποία προσυπέγραφαν εκ μέρους τους οι κύριοι Χαράλαμπος Θεοπέμπτου και η κυρία Αλεξάνδρα Attalides, η οποία σήμερα είναι παρούσα στο πάνελ. Δεν γνωρίζω την τύχη της πρότασης νόμου, ίσως η κυρία Attalides σε μια παρέμβαση της μελλοντική να μπορεί να μας πει. Το αποτέλεσμα των συζητήσεων είναι ότι, όπως ψηφίστηκε ο νόμος, η αρχή παρέμεινε με ερευνητικές και όχι ανακριτικές εξουσίες. Δεν θα προβώ σε ανάλυση τη διαφορά των δύο, διότι θα ήταν αρκετά χρονοβόρο. Ξέρω ότι έχω στη διάθεσή μου περίπου 10 λεπτά για να εξηγήσω τις βασικές αρχές. Με το διορισμό των 5 μελών της αρχής, ήταν θέμα ύψης της προτεραιότητας η ψήφιση κανονισμών λειτουργίας. Τη σύνταξή τους ανέλαβε η ίδια η αρχή σε συνεννόηση με το Υπουργείο Δικαιοσύνης και Δημόσιας Τάξης και αφού πέρασαν όλα τα στάδια, τέθηκαν σε ισχύ στις 16 Δεκεμβρίου του 2022. Οι κανονισμοί αυτοί εμπεριέχουν σαφείς πρόνοιες ως προς τη διαδικασία που ακολουθείται στην εξέταση καταγγελιών και μετά τη ψήφιση τους η αρχή μπορούσε να προχωρήσει με την εξέταση καταγγελιών. Οι πυλώνες των αρμοδίτων και εξουσιών της αρχής είναι βασικά 4. Πρώτον, η διερεύνηση καταγγελιών και πληροφοριών. Δεύτερον, η εποπτεία των δράσεων του δημόσιου και ιδιωτικού τομέα σε θέματα πρόληψης και καταπολέμησης της διαφθοράς. Τρίτον, η συνεργασία με διεθνείς οργανισμούς για θέματα πρόληψης και καταπολέμησης της διαφθοράς. Και τέταρτον, η εφαρμογή του νόμου του lobbying. Όσον αφορά τη διερεύνηση καταγγελιών και πληροφοριών, η αρχή διερευνά καταγγελίες που υποβάλλονται σε αυτήν οι πληροφορίες που περιέρχονται εν γνώση της και οι οποίες σχετίζονται με πράξεις διαφθοράς στο δημόσιο τομέα, ευρύτερο δημόσιο τομέα ή ακόμα και τον ιδιωτικό τομέα, εάν σε αυτές εμπλέκονται άτομα του δημόσιου τομέα. Η αρχή μπορεί να ενεργήσει και αυτεπάγγελτα προς τον ίδιο σκοπό. Η υποβολή καταγγελιών και πληροφοριών μπορεί να γίνει και ανώνυμα. Η αρχή εφαρμόζει μια εντελεχή προκαταρκτική εξέταση της κάθε καταγγελίας για να αποφασιστεί κατά πόσον αυτή εμπίπτει εντός των αρμοδιοτήτων της και κατά πόσο εμπεριέχει επαρκή στοιχεία διαφθοράς για να προχωρήσει σε μεταγενέστερο στάδιο, σε άλλο στάδιο η έρευνα. Από τα μέχρι τώρα στοιχεία φαίνεται ότι η κοινωνία επιδεικνύει εμπιστοσύνη στην αρχή, εφόσον από τον Δεκέμβριο του 2022 μέχρι σήμερα υπευλήθηκαν συνολικά 290 καταγγελίες. Καταγγελίες αυτές προέρχονται βασικά οι περισσότερες από ιδιώτες, αλλά και από θεσμούς και οργανισμούς. Οι 75 από τις 290 είναι ανώνυμες. Έχουν εξεταστεί και διερευνηθεί συνολικά 85. Σε περίπτωση που η αρχή, μετά από έρευνα, καταλήξει στο συμπέρασμα ότι κάποιο πρόσωπο ενδέχεται να έχει διαπράξει πράξη διαφθοράς, αποστέλει την εισήγησή της στον Γενικό Εισαγγελέα, ο οποίος είναι ο αρμόδιος να αποφασίσει για τα περαιτέρω. Προτού εγκαταλείψω αυτό το κεφάλαιο, θα ήθελα να αναφερθώ σε κάτι το οποίο κρίνω σημαντικό. Στα πλαίσια του ερευνητικού της έργου, είτε όταν η ίδια συλλέγει πληροφορίες, είτε όταν εξουσιοδοτεί τους λειτουργούς επιθεώρησης να ενεργούν εκ μέρους της, η αρχή έχει συντάξει πρότυπα κλήσεων, τα οποία επιδίδει στους ενδιαφερομένους. Οι κλήσεις αυτές μπορεί να είναι είτε για μαρτυρία, είτε για προσαγωγή εγγράφων, είτε και για τα δύο. Το σημαντικό σημείο που θα τονίσω σε αυτό το στάδιο είναι η καθολική και σχεδόν άμεση ανταπόκριση όλων, γεγονός που διευκολύνει το έργο της. Έχουν εκδοθεί δεκάδες, μπορεί να ξεπερνούν και τις 150 οι κλήσεις οι οποίες έχουν επιδοθεί και μόνο σε 2 περιπτώσεις δεν υπήρξε συμμόρφωση. Θα ήθελα σε αυτό το στάδιο επίσης να αναφέρω ότι με βάση γνωμάτευση την οποία έχουμε λάβει, η αρχή δεν μπορεί να διεκδικήσει τα δικαιώματά της με ιδιωτικές ποινικές. Σε περίπτωση, για παράδειγμα, παρακοής κάποιων προνοιών της νομοθεσίας, δεν έχει δικαίωμα να καταχωρήσει η ίδια ιδιωτική ποινική προς το σκοπό αυτών. Πρέπει όλες να απευθύνονται προς την νομική υπηρεσία. Δεύτερος πυλώνας είναι η εποπτεία των δράσεων του δημόσιου και ιδιωτικού τομέα σε θέματα πρόληψης και καταπολέμησης της διαφθοράς. Οι αρμοδιότητες και ενέργειες της αρχής στο κεφάλαιο αυτό είναι συνεχείς και έντονες. Είναι δράσεις οι οποίες περιλαμβάνονται στην Εθνική Στρατηγική κατά της Διαφθοράς, καθώς και στο Οριζόντιο Σχέδιο Δράσης και οι οποίες αποσκοπούν στην πρόληψη και καταπολέμηση πράξεων διαφθοράς. Μέχρι τον Ιούλιο του 2023, την ευθύνη για τις δράσεις αυτές είχε το Υπουργείο Δικαιοσύνης και Δημόσιας Τάξεως, το οποίο είχε συμπληρώσει σχεδόν όλο το σχέδιο το οποίο είχε σχεδιάσει. Η αρχή ανέλαβε τα ενία τον Ιούλιο του 2023 και με βάση ανάληψη δέσμευσης μέχρι το τέλος του 2024 θα πρέπει να έχει δημιουργήσει ένα νέο σχέδιο δράσης και να το έχει θέσει σε πλήρη εφαρμογή. Ήδη κάποιες δράσεις έχουν αναλυφθεί όταν επιβάλλεται επιμόρφωση κάποιων φορέων, των αρμόδιων φορέων. Αναφέρομαι στα θέματα διαφθοράς, επιμόρφωση σε θέματα διαφθοράς και ιδιαίτερα στο θέμα του lobbying. Τρίτο, συνεργασία με διεθνείς οργανισμούς για θέματα πρόληψης και καταπολέμησης της διαφθοράς. Στα θέματα διεθνούς συνεργασίας έγιναν μεν κάποια βήματα, αλλά υπάρχουν ακόμη πολλά να γίνουν. Ο λόγος είναι επειδή δόθηκε προτεραιότητα στα θέματα των καταγγελιών και του lobbying και με τον υποστελέχωσή της θα ήταν δύσκολο να γίνουν ενέργειες προς το σκοπό αυτών. Έχει όμως υπάρξει συμμετοχή μας σε συνέδρια της Διεθνούς Διαφάνειας, είχαμε επαφές με την Εθνική Αρχή Διαφάνειας της Ελλάδας, ενώ είμαστε μέλη του European Network for Public Ethics και του Network of Corruption Prevention Authorities με συμμετοχή σε συνέδρια και webinars. Μία από τις ερωτήσεις που έχει υποβληθεί από την Δόκτωρα Μαρία Καπαρδί είναι κατά πόσον υπάρχει συνεργασία της αρχής με την International Association of Anti-Corruption Agencies. Είναι γεγονός ότι πρόκειται για έναν αξιόλογο οργανισμό, αλλά δυστυχώς μέχρι σήμερα δεν είχαμε την ευκαιρία να έχουμε σχετικές επαφές. Τέταρτος πυλώνας είναι η εφαρμογή του νόμου του lobbying. Επειδή στα πλαίσια του Cyprus Forum θα υπάρξει χωριστή συζήτηση για το θέμα του lobbying, στο οποίο θα συμμετάσχει το μέλος κυρία Έλενα Πατέρα, που είναι υπεύθυνη της ομάδας lobbying της αρχής, θα αρκεστώ σε αναφορά κάποιο σημαντικό σημείο. Θα περιέγραφα τον νόμο του lobbying ως έναν επαναστατικό νομοθέτημα, το οποίο επιφέρει ριζικές αλλαγές στον τρόπο που μέχρι τώρα διευθετούνταν συναντήσεις μεταξύ προσώπων και αξιωματούχων, με σκοπό τη λήψη δημόσιων αποφάσεων. Σκοπός του νόμου είναι η εμπέδωση διαφάνειας στις διαδικασίες λήψης δημόσιων αποφάσεων για αποφυγή πράξεων διαφθοράς. Πρέπει να σταματήσει αυτό το οποίο γινόταν μέχρι σήμερα, να λαμβάνονται αποφάσεις μυστικά πίσω από κλειστές πόρτες και να υλοποιούνται χωρίς να υπάρχει διαφάνεια. Η αρχή, ως αρμόδια για την εφαρμογή του εν λόγω νόμου, έχει θέσει σε εφαρμογή όλες τις πρόνοιες του σχετικού νόμου. Παρά τις αρχικές αντιδράσεις τόσο από υποψήφιους λομπίστες, αλλά και από αξιωματούχους, αντιδράσεις που αφορούσαν τις υποχρεώσεις που πρέπει πλέον να αναλαμβάνουν, άρχισαν, πιστεύω, όλοι να συμμορφώνονται. Μέχρι σήμερα έχουν εγγραφεί 97 λομπίστες, ενώ εκκρεμούν άλλες 50 αιτήσεις για εγγραφή. Από την άλλη, αξιωματούχοι ζητούν συνεχώς ενημέρωση για τις πρόνοιες της νομοθεσίας και η αρχή ανταποκρίνεται θετικά σε όλα τα αιτήματα. Ως επίλογο, θα ήθελα να αναφέρω την νομοθεσία για την προστασία των δεδομένων προσωπικού χαρακτήρα. Κάποιος που διαβάζει τον νόμο της αρχής βλέπει συνεχώς πρόνοιες για τήρηση της νομοθεσίας και κανονισμών που αφορούν στην προστασία των προσωπικών δεδομένων. Μάλιστα, υπάρχει ρητή απαγόρευση δημοσιοποίησης οποιασδήποτε πληροφορίας η οποία λαμβάνεται από την αρχή στα πλαίσια των αρμοδιοτήτων χωρίς την έγκριση του Επιτρόπου Διαφάνειας. Δυστυχώς, αυτή η πρόνοια δεν τηρείται, όχι από εμάς ως αρχή, αλλά από άτομα τα οποία ίσως καταγγέλουν όταν τους πληροφορήσουμε ότι η καταγγελία τους έχει προχωρήσει στο επόμενο στάδιο ή ακόμα και την ημέρα που υποβάλλουν την καταγγελία, κάποιοι έχουν την τάση να τη δημοσιοποιούν. Αυτό αποτελεί ποινικό αδίκημα, αλλά και πάλι δεν μπορούμε εμείς να ανταποκριθούμε ούτε να στέλνουμε κάθε υπόθεση στο Γενικό Εισαγγελέα για τα περαιτέρω. Υπάρχει από τη μία η προσπάθεια να μην στοχοποιούνται τα άτομα τα οποία καταγγέλλονται, ιδιαίτερα αν δεν αποδειχθεί οτιδήποτε και απορριφθεί η καταγγελία. Και από την άλλη, η διαφάνεια, η οποία πρέπει να διέπει κάποιες περιπτώσεις και είχαμε έντονες παραστάσεις ότι δεν δημοσιοποιούμε κάποια θέματα. Θυμούμε μια έντονη παράσταση που είχαμε από την κυρία Attalides στη Βουλή, ότι πού είναι η διαφάνεια. Οφείλω να πω ότι έχουμε να ισορροπήσουμε από τη μια τη μη δημοσιοποίηση των πληροφοριών και από την άλλη τον τίτλο τον οποίο φέρω εγώ ως αξιωματούχος Επίτροπος Διαφάνειας. Πρέπει να ισορροπηθούν. Είμαστε σε πολύ καλή συνεργασία με την κυρία Λοϊζίδου, την Επίτροπο Προστασίας Προσωπικών Δεδομένων. Είχαμε συνάντηση και εκεί που καταλήξαμε είναι ότι η κάθε υπόθεση πρέπει να κρίνεται στα δικά της γεγονότα. Δεν μπορεί να τεθούν αυστηροί κανόνες και επομένως αυτή την πρακτική να ακολουθούμε. Στόχος μας είναι μη στοχοποίηση ατόμων, ιδιαίτερα όταν αυτά στο τέλος δεν αποδειχθεί ότι έχουν οποιαδήποτε ευθύνη. Σας ευχαριστώ.
Thank you, Mr. Boyiadjis. I think, given the discussion, and sorry for the purpose of Ms. Anouilh, who is listening and hasn't had the privilege of listening to you, I think we just need to let her know that the Commissioner has just told us of the establishment of the Anti-Corruption Agency in Cyprus and what it has achieved thus far. On that basis, given Mrs. Attalides was one of the legislators involved, maybe you want to share with us how you see the Commission, how it has progressed, how it has evolved the last year or so, what you would like to see different?
Okay, I will say that it's a step forward, of course, but on the other hand, in Cyprus we have many commissions and many people investigating, and we have a lot of overlapping powers, and that is not good if we want to really fight corruption. I have to say that to combat corruption, you have to have an unwavering political will, first of all, that I think we don't have in Cyprus. We have to have a zero-tolerance culture, which is something that is built. You cannot acquire it in one day or two. You need education, but you need also enlightened leaders that they should put it at the top of the agenda, and it should be the integrity and accountability, which demonstrates a firm stance against corruption. We don't have that in Cyprus. We don't have. What we have is every time that the government changes, the previous government starts to criticize the current government about corruption, about scandals. But nobody acknowledges the scandals of their own government. And that is a very big problem that we face all the time in the parliament. When a scandal comes in front of a committee to be debated, you see that the members of the parliament that they belong to the government that was in power when the scandal took place, they are on the defensive. And this is very bad. It means that we have a culture of covering those that we consider ours. And for me, this is very bad. The second thing that I want to say is that, Mr. Boyiadjis may remember, we had terrible fights in the parliament because I was of the opinion that Such a commission requires interrogation powers, that they should carry on their interrogation. What happened is that all the other parties were against us. So we were alone, and our amendment was voted down. But I still believe that the authority needs interrogation powers, because what happens in Cyprus is very unique. If they conduct an investigation and they have evidence that there is a penal, how do you call it in the legal matters? There is evidence of penal activities, etc., etc. What?
Criminal offense.
Yes, criminal offense. Then they have to stop the investigation and handle the envelope to the prosecutor, to the Attorney General. In my opinion, this is wrong. I think that we need to have more than one authority that carries investigations, especially in corruption. Why? Because the Attorney General is the advisor to the government, okay? And that is, in my opinion, a problem when you investigate corruption. When you investigate corruption, you want an independent authority that has no connections whatsoever with the government. In a lot of the cases that we have now, we see that the legal service of the Republic gave opinion. And now we face some projects and we want to investigate what happened. So the legal authority, the Attorney General, they were involved in many of these late scandals, like we say, Basilico, Larnaca Marina and Port. So how can you investigate something that you were involved as advisor of the government? There is a conflict of interest, in my opinion. And what I want to say is that the authority has the competence to investigate, to start ex officio. In the law, they have the competence to do that. I am expecting to see them to be more proactive, not to wait for people to report things. I believe that a major step forward is for the authority to start on its own investigations, because this will give a message of accountability, transparency, maintaining public trust in the authority, because people are losing trust in everything these days. So I think they will maintain trust in the authority, and of course it will reassure citizens and stakeholders that the Commission is committed to addressing potential abuses in power in Cyprus.
Thank you.
Sorry
for that.
I took too much time.
No, that's fine. I think that brings us then to the issue of that there are different anti-corruption agencies around the world. The first anti-corruption agency was set up in the 1960s in Singapore. Then came in 1974 the one in Hong Kong, and in 1988 the one in New South Wales in Australia. In Europe, the anti-corruption agencies came a little bit later. Now there are 4 different models. There is the universal model, where the agency is accountable to the executive. There is the investigative model, which has investigative powers only. There is the parliamentary model, where a report is submitted to the parliament and is independent of both the judiciary and the executive. And then there is the multi-agency model, where there are different agencies set up for the fight of corruption. Now, whatever the model selected, the public needs to be able to hold anti-corruption agencies to account and to consider agencies legitimate in monitoring their progress against stated objectives. On that note, I'd like to ask Ms. Anouilh, from the International Relations Officer of the High Authority of Transparency in Public Life from France. Is that right?
Yes, can you hear me?
Yeah, thank you. Now, reading through your organization's annual report, which was very impressive, in 2023, you stated that you've received over 8,000 asset declarations. You carried out quite a few thousands of of audits. Only a handful has gone to court. The same thing relating to revolving doors. You had over 400 revolving door cases and a number of lobbying activities. Does your agency reviewing asset declarations, revolving doors, lobbying activities, is it restricted only to this investigating these three areas? Could you share with us your experience, please?
Yes, thank you so much for inviting me to this panel. Indeed, the high authority controls the declaration of assets and the interest of public officials. It has a mission of lobbying also, and the lobbyists have to register on a directory held by the high authority. But also, the high authority is responsible for controlling a declaration of interest and has a mission of preventing conflict of interest. The high authority does not only have a mission of control, it has a transversal mission of disseminating a culture of integrity by supporting, advising, and organizing training and seminars for public officials. You were indeed talking about a culture of zero tolerance, and I think it takes time. Of course, some authority like ours, the high authority, can help disseminating this culture of integrity and zero tolerance. But I think it's also they have to train and form all the public officials in order to gain that culture of integrity.
Right. Thank you for that. Ms. Yoojin, Choi.
Yep.
You are the head of training and capacity development department of the Anti-Corruption Academy, but previously you were in the Korean Anti-Corruption Agency. Yeah?
Correct.
Yeah. So I was wondering whether you could share with us whether there is any collaboration between the Academy and anti-corruption agencies, or whether there is any training that you carry out, especially for these officers.
For the anti-corruption agency officers, we are working with the different regions and different part of the world. But before joining the International Anti-Corruption Academy, which is based in Austria, I was working for my government 10 years as a government official, and then 6 years leave of absence serving during the IACA, International Anti-Corruption Academy. We work, as you can imagine, closely working with anti-corruption agencies all over the world. And also we are developing the anti-corruption agency model development so that I can relate with some of the models you mentioned at the beginning. And I work closely with the Hong Kong ICAC, CPIB, as well as also the Australian colleagues as well. So for the Korean model, something is very unique. I can give you a little bit of the background and the information that might be also helpful for the Cyprus Commission, in a way that we really had a strong support from the civil society from the beginning. Anti-Corruption Act itself was actually launched, and actually it was enacted thanks to the government, not the government part, but from the civil society. The biggest support coming from the Transparency International. So we had a strong support from the civil society, in addition to the leadership. Our then president was leading the anti-corruption drive very strongly. And later, when we launched, we had a law 2001, and then 2002, they launched the anti-corruption agency size of about 100 people. Initially, but within a year or two, and they became 200, and now they merged the function of the ombudsman together, and now it's a 600 staff members at the moment. But what I want to say there, what we were gaining the momentum from the leadership is that we had inter-agency government meetings, which was held every quarterly, presided by the Korean president. So the anti-corruption agency was responsible for organizing this agenda, and also the collecting all the minister levels, and like Ministry of Justice and Taxation Office, FIU, anyone and everyone involving in the anti-corruption field joining together, and that kind of shows the really strong will, political will, and that helped the agency to get also the the power and what they needed. And initially that the step was not all selected as the government career official, but they also have a lot of secondment from the public prosecutor's office and also the police. But later they gain and more their own step, but still they do have some secondment officials serving and working closely. And also, Commissioner also mentioned that the whistleblower issue, and then whistleblower protection is the responsibility of also the anti-corruption agency. So they are having quite a strong power, because not only the public sector, but also the private sector for the public interest related matter, then the ACRC Korea can protect the private sector people as well, which is quite a big achievement and also very strong, because we are also the OECD working group of bribery member, and that was one of the recommendations was given to Korea to make changes. So here I should stop.
Thank you, that was really helpful. Thank you so much. Mr. Chatzigiannakis, you are the president of the board of Transparency International in Greece, and I understand there is good collaboration between your civil society and the anti-corruption agency in Greece. Maybe you can share that experience with us.
Sure. Thank you very much. I need 60 seconds to explain what Transparency International Greece is. We are the branch office of Transparency International, which is an international movement based in Berlin with over 100 branch offices in the world. We have been established in 1996 as a Somatio, and our vision is a world free of corruption. We define corruption as the abuse of entrusted power for private gain. Our scope is to fight against corruption, and how we do that is by introducing and advocating for the regulation of whistleblowing, beneficial ownership, lobbying, asset declaration, etc. So different means for power to be held accountable. We also use informing and sensitizing the public, but also major corporations, and also by research. Our flagship research tool is the Corruption Perception Index, which ranks 180 countries and measures the corruption in the public sector, taking into consideration the opinion of experts and business people. Some food for thought. I have to tell you that number one as a transparent country is Denmark, with a score of 90 points out of 100, so it's almost perfect. Cyprus is ranking 49 with 53 points, and Greece 59 with 49 points. So there's a difference of 4-5 points and many places. Since 2019, we have in Greece the National Transparency Authority, η Εθνική Αρχή Διαφάνειας, NTA. The relationship between NTA and our organization can still be described as rather basic and introductory. Specifically, there are fragmented rather than comprehensive interventions and collaborations. While Transparency International Greece is involved in working with groups providing input on topics such as lobbying, whistleblowing, and public procurement, we strongly believe that there is a need for a deeper collaboration between our organization, the National Transparency Agency, and other public authorities in general. To some extent, this is regarded as a cultural political issue in Greece, in the Greek public sector, since they are not particularly receptive to intervention and suggestions from the civil society organization. It has been frequently stated that the dialogue often resembles opposition rather than being constructive. Of course, our role as supervisor is primarily supervisory, as an internationally recognized organization, but I would say that in recent years we have extended an invitation for collaboration to public authorities. We have expressed our readiness for a constructive and targeted partnership. Clearly, the relationship between TI, Transparency International Greece, and NTA is complicated, since on the one hand, we must be ready to criticize any shortcomings, but on the other hand, we have to stay open to collaboration for a common scope.
Yeah, that makes sense. Thank you for that. I think now we can turn to the Commissioner for Personal Data Protection, Ms. Irene Loizidou-Nikolaidou. I think you agree with me that we can, that transparency is a tool for combating corruption. Yet there is a common belief that privacy sometimes hampers or impairs transparency. Could I please have your comments on that?
Yes, thank you very much. First of all, allow me to thank the organizers for inviting me once again to participate to this useful and important forum. And of course, I do agree that transparency is one of the tools against corruption. I disagree, though, that privacy is an obstacle. This is just a misconception, and as I will explain, it is far from the truth. Accountability and transparency are core principles of the GDPR. Accountability means that an organization needs at all times to demonstrate compliance. Transparency means that processing of personal data must always be carried out in a transparent manner to the concerned individuals. In the GDPR's preamble, it is explained that the protection of personal data is not an absolute right, and that processing of such data should be designed to serve mankind. The right to data protection must be considered in relation to its function in society and be balanced against other fundamental rights in accordance with the principle of proportionality. Such rights include freedom of expression and the right of the public to have access to official documents in accordance with national laws. From this text, we can conclude that the GDPR sets two obligations. First, when we face questions of privacy and transparency as a tool of combating corruption, we have to strike the right balance between the rights of individuals and the goals we wish to achieve. Second, these goals should be defined in or imposed by law to serve the greater good. They should not, for example, aim at giving food to gossip. The Court of Justice of the EU and the European Court of Human Rights have given us guidance how to carry out this balancing test and about the criteria we should take into account on a case-by-case basis, as Mr. Boyiadjis mentioned. For example, when we consider to publish information about a person suspected for corruption, we should take into account criteria such as if the person is publicly exposed or not, if the information we have is accurate, if the information concerns the private or the professional life of this person, and if concerns an event that took place in a private or in a public place. These criteria will help us decide if the right of the public to be informed about the alleged corruption overrides the rights, freedoms, and interests of this person. To conclude, yes, transparency can fight corruption, and yes, we can have transparency with respect to privacy. Thank you.
Right, thank you for that. Thank you. Turning now to Leto Cariolou. Leto, in your view, what are some of the issues or concerns that you have regarding the existing anti-corruption agency in Cyprus?
Thank you. Well, I'll try to be practical.
Yeah.
Being practical is not my strongest characteristic, but I'll try in an effort to make us at least consider certain issues that merit, I believe, our attention. So before we discuss concerns, let's talk about the positives. We have a law, we have an independent authority, they've got plenty of complaints to examine, they also have the powers to initiate ex proprio motu investigations. What is interesting, and in my view a great strength of the authority, is the fact that they're not bound by strict rules of admissibility of evidence, and this is very important. It is also a strength, in my view, that the standard of proof that is applied by the authority is that on the balance of probabilities. So it's not the criminal law standard, but it's a lower standard, which is beneficial when it comes to making findings. Now, if we're serious about tackling the series of corruption that have been of concern, in my view, we really need to reconsider the powers, the investigative powers of the Anti-Corruption Authority, and give them full powers to investigate. This would include, in my view, the power to arrest, instruct essentially the police to arrest someone when there's reasonable grounds to believe that such arrest is warranted, the power to apply to the courts for seek and seizure orders and warrants, as well as the power to prosecute. Now, the second issue I would like to raise is that we really need to reconsider Section 10 of our law, which creates this odd position that basically any planned or ongoing investigation by the independent authority will need to be suspended, if you like, terminated, if there's a decision to investigate, if there's a decision to initiate criminal investigation, either by the police, the Attorney General, or perhaps by the Ministerial Council. And this is clearly problematic, leaving aside from issues of any scenario involving a deliberate intent to shelter any specific individual from responsibility. Just consider for a moment the great waste of resources that this would imply. If there's a serious investigation ongoing for a considerable length of time, it's a very odd situation that any findings or any work done needs to be thrown to the bin, if there's such a decision. The other point I would like to raise as food for thought, especially given the presence of Mrs. Attalides, because this is a matter for the Parliament, I believe, to consider, is that it would be interesting to give the authority the power to initiate civil proceedings where there are reasonable grounds to believe that a person has been a party to any corruption and has benefited from it. So this would be interesting, and it would not require essentially, reform of the Constitution. We're not talking about the criminal proceedings or the criminal law sphere. We're talking about civil proceedings. And indeed, one could envisage that we give a parallel power to the victims to initiate such, proceedings to seek damages for basically compensation for any damage suffered as a result of corruption. So, we could model such provision. I believe a similar provision exists in the Seychelles Commission. I believe it's Section 77, which provides that a person who does anything that constitutes corruption is liable to any person or victim who suffers loss or damage as a result. Now, another issue that is worth considering is witness protection. I think that we could envisage making specific provisions so that the authority can protect witnesses that come forward and testify, both in terms of ensuring their safety as well as sheltering them from any consequences as a result of whistleblowing, as well as the power to stop and prevent witness intimidation. And I will leave that for further discussion. But the last point I wanted to raise is we need to consider seriously how independent commissioners can be dismissed, especially after the Supreme Court's judgment, recent judgment. One could expect a fruitful dialogue between the Parliament and the Supreme Court as to what constitutes inappropriate behavior, and insert such criteria into the law, so that the Supreme Court in any future case has some criteria that can be perhaps of use, but also so that the holders of such posts are notified and know what is indeed expected of them, which I believe would be helpful and a move towards greater legal certainty, if you like.
Thank you, Leto. I think you've given us a lot of food for
Can I
thought.
add something?
Before you do that,
Also, the selection should have the criteria, not only the dismissal.
Yes, I mean,
Selection and dismissal.
before I come to the legislature, I wanted to hear Mr. Boyiadjis' comments on those, and how do you see those suggestions put forward by Leto?
I will start from the last point of Mr. Attalides, selection. It's one of the first laws which there is an advisory report which selects and suggest to the president which persons to appoint. 3 for each position. So it's an improvement. Okay, it can be better improved in the future. Now, concerning the effort to prosecute our own cases, we cannot do that, especially corruption cases. Even now, even if we acquire criminal investigation powers, the reason is simple. We need to amend the Constitution. And when members of parliament or government hear that, they just get terrified. You know, amend the Constitution again. We did this so many times. So I think probably with the amendment, which will come soon, to divide the powers of the Attorney General in the Director of Public Prosecutions and the Advisor of the Government, probably we can put that into as food for thought. So at the moment now, we're helpless on that respect. And even we cannot, as I said, initiate proceedings for somebody who doesn't come to the committee, to the investigation. We tried to do that. The Attorney General refused to do that. We got an opinion from our lawyer that we cannot do that. So we didn't, it's the first time I'm saying that, because we don't normally publicize the decisions, but we got an opinion, legal opinion, we cannot do anything about that. So we just sat quiet and we didn't say that in public. Whistleblowing is a very big chapter. We had discussions with Olaf and with many European bodies. It's only theoretical. In practical, I think everybody agrees that there is no practical way to protect whistleblowers. They just give them a right for compensation, but the main thing is that to encourage somebody to go forward and report, and at the same time, give him protection. Now, how to give him protection during the investigation is very difficult, because you can put him in another department, you can give him leave with a salary so that they get away from that environment until the complaint is investigated, but we don't have anything like that. I think nowhere in Europe. I'm not sure, but I think that's the situation in Europe. Nobody protects whistleblowers pending their complaint. So it has to be, the framework has to be improved.
Yeah, I think Mr. Attalides is...
I think in some countries, when a whistleblower comes forward, then you cannot start an investigation against the whistleblower at the same time. That we've seen it in Cyprus, in my opinion, in one case. So there are steps to take, because if I know that when I come and I say something that I've seen which needs investigation, and the next day I have 3 investigations, then the next one will never come forward. And this is the case that happened in Cyprus. In my opinion, it hampers a lot people coming forward.
Can I just respond to that? I think he's not obliged, the employer is not obliged to do that. We had an example when somebody reported their employer, and we just sent a letter to the employer saying that, look, he reported corruption, just to let you know, and he stopped the proceedings against that employee. That's what he did, but he did it on his own will. So we couldn't force him, we couldn't go to court and ask for an order or something. We just sent a letter. That's what we did.
I think it'd be interesting to hear from our guests from Greece, France, and Korea.
If I may, very shortly, in the Greek labor law, there is protection for whistleblowers, and it's forbidden to dismiss them.
Yeah, even reinstate the dismissal, so that there is a power for the anti-corruption agency could request the former employer to rehire that person. But also, the interesting thing is the Korea Independent Commission Against Corruption hire whistleblowers from their side. Right. So we know that some of the staff members are the whistleblowers from the other public institution, but they are hired by the anti-corruption agency as a staff member. And also there is a reward money and also the award money. So they give the money when the money returned to the government, but in the meantime, they also provided some money with a percentage they are calculating. And in addition, they also provide the service, legal service, having a lawyer who's supporting to this whistleblower, which is really needed.
Oh, that's also interesting. Ms. Anouilh, could we have your comment from France? What do you do regarding whistleblowers? How do you protect them?
Hello. Well, the High Authority does not have a mission of protecting her whistleblowers yet, and I'm not sure it's going to be one of our missions. So I cannot really debate about that.
Okay. What I am aware is that in some countries, well, generally, whistleblowers don't only suffer financially, but they also suffer psychologically and legally. So a lot of countries offer legal support, psychological support. The entire family might need support. So that's something that that can also be considered maybe in supporting generally the whistleblowers, not just making sure that they don't get sacked. Mr. Attalides, is there something that you would like to see improved with the ICAC in Cyprus?
Well, as I said, we need results, concrete results. We need a research that will end up with results. When the people see that, they will begin to trust. Now there is no trust. It's commonly, I think, discussed and everybody accepts that people lost their trust in the institutions. So I believe that the institutions, they have to really make a big effort to show that they mean business. And when I say mean business, it means that whoever is the person, they should investigate, and they should deliver, and they should be transparent, and they should be accountable. And this is one way to establish the authority as what I believe should be the authority, should be the advocate of citizens, of society's benefit, the public interest. They should defend the public interest. And we are waiting to see that, because I don't know how many of these cases are finished, finalized, how many people are going to be prosecuted. Unless we see results, in my opinion, is that we spend a lot of money in Cyprus in investigations, but we never see real results. This is Eric, there, you know, we worked together some years ago on a platform for transparency against corruption, and I can tell you that in Cyprus, it's not only that there is not a culture against corruption, but the people who work against corruption, I think they face a lot of problems, not only in their professional life, but also in their personal life. Because in Cyprus, I think it's Aristotle who said that a good citizen in a bad society is considered a bad person. Because when everybody else accepts that this is a very good government and you come out and you say, no, this is corrupt, you are the only one, most probably, or one of very few, then you become a very bad person in the eyes of everybody. And this is a problem in Cyprus. But I want to say something. In Australia, for example, they can even intercept telecommunications, the authority. Not only that, they obtain warrants for to search properties. And I have to tell you something. In Cyprus, some years ago, a big scandal came on television. It was a video showing two people that they were in very important key positions, and they were talking something that was considered as corrupt. 15 days after, the police got a warrant to enter the houses and take the computers. I am sorry. 15 days after. This should have been done the very first day. Get a warrant from a judge and investigate and take the evidence. 15 days after, there is no evidence whatsoever.
Mm-hmm. I think we will have 10 minutes at the end with questions.
But Eric, you know, he's somebody who comes to the parliament also. He's very knowledgeable, maybe. he will add something
I
to.
think what we need to realize, however, is that our ICAC in Cyprus is fairly new, and comparing the budget that our ICAC has to ICACs overseas is very minimum. So maybe we should give them some benefit of the doubt.
Oh,
Let's
yes.
see, yeah, and maybe more money should be going forward to
And
to
staff,
the ICAC.
and buildings,
staff
and investigators,
exactly,
everything, yes.
Can I just say something?
Yeah.
Mrs. Attalides said she wants to see results. If she means results from us, I would say, and by results she means people who are liable for criminal offenses of corruption, 2 words, very soon. You will see that. Now, results for me, being a former judge, means taking them into court, condemning people and putting them to jail. This is not up to us. This is up to somebody else.
I know.
We can do nothing about it.
I know, but that's why you have to be transparent. You said that
my
you
God.
cannot, that's the
We had this at
problem.
the parliament, we have this
That's the
again.
problem. Because if you don't say that I finished this,
No, we'll say that
Yes.
without any names. Okay.
Okay, so we'll see the annual report when it's published. Could I have now your closing remarks, please, before we give the floor to the...
as I said before, I am going because I have the parliament. My approach to this is zero tolerance, but it takes years. And the thing is that I think maybe Mediterranean cultures are more susceptible to corruption because we have the families, the friends, the extended family. We want our child to go to the good school, so we may pick up the phone and find a good school. So we teach our children from a very young age that if they have powerful parents, they may have privileges. I think we must strengthen equality in our society. Equality, all citizens should be equal in front of the law and in front of institutions and the government. When we strengthen equality, this notion that we are equal and we can demand our rights and we should report when we see something that is against the law, then we will start to create a culture that discourages corruption. And maybe this, but it will take years. I am not very, let's say, optimistic about it at the time being.
Thank you. Mr. Chatzigiannakis.
If I may make a comment on what you just said, that I would like to inform you that both Transparency International Greece and the National Transparency Authority are committed to fostering the values of transparency, political integrity and ethics in schools and educational institutions. Recently, our organization visited the Greek town, Xanthi, to conduct various workshops with children based on a book written to promote integrity among young audiences. Similarly, the National Transparency Authority, in collaboration with the Ministry of Education and other partners, organizes a nationwide student competition under the broader title Leaders of Integrity for Tomorrow. These initiatives aims to raise awareness within the school community about the values of transparency and integrity. It has been recognized as an international best practice for engaging the younger generation and actively contributing to the gradual development of a culture that minimizes the scope of corruption. And my closing comment is that the establishment of the National Transparency Authority in Greece is extremely positive. However, is not a panacea.
Thank you. Mr. Loizidou, your closing
Three
remarks.
key quick messages. First of all, as I said before, several EU and national legislations dictate proof that we can be transparent, fight corruption, and ensure embrace privacy at the same time. Second, striking the right balance between fundamental rights is not always an easy task. Some cases may be less straightforward than others. And final remarks, answers can always be found when offices like Mr. Boyiadjis and mine cooperate effectively and when guidance, when it is needed, is given. Thank you.
Thank you. Thank you. Ms. Choi.
get there are more and more measurement about the anti-corruption effort, measurement within the government and then within the government authorities are one of the as a tools for the anti-corruption agency these days are using, and then that could give also the name and shame approach to all the agencies, and also giving attention more to what commissioner and commission would like to do, and that's also used by the many different countries at the moment. And then IACA is also doing making an effort to the anti-corruption measurement related issue. And also we would be very happy to discuss with the commission that whether they need any niche or help or any capacity building and technical assistance from your side, not only the face-to-face, but we also provide the virtual trainings, and also we provide a pro bono trainings through our webpage as well. And lastly, we also value the education of the young students, and we are providing some pro bono programs together with IACA UNODC schools as a targeting to the different regions. So Cyprus was one of the times of also the regions, so please take a look at it, and then also encourage the youngsters. And this is with the Austrian Fund, Ministry of Foreign Affairs, we are providing this program twice per yearly. And IACA happy to provide also the training trainers training for the educators for the ethical dilemma and also the behavior science related matters. So we would really explore the options to collaborate more with Cyprus in the near future.
Thank you. Mr. Boyiadjis, your closing remarks.
In Cyprus, society doesn't trust anymore any institutions. We have lost all the trust we had in the courts, in the corruption authorities, police. What we need to do is work together quickly and decisively. As Mrs. Attalides said, we cannot, if we have a report of a case of corruption, we have to go get the search warrant, get the evidence, the second day, the first day, and work together. If we don't do that, the trust will be lost completely. Now, if we're going to do that, I won't comment. I have my personal opinions, but it's better not to say it. So I will leave that for you as food for thought. Thank you.
Thank you. Ms. Cariolou.
Not so much of a closing remark, rather clarification to what I said previously. When I talked about the need to protect witnesses that blow the whistle, I meant specifically within the framework of the anti-corruption authority, because of course there's an EU directive on the protection of whistleblowers which has been implemented in our system. Our law goes much beyond what the directive provides, in fact. But yeah, I share Commissioner Boyiadjis' concern as to, practically speaking, how much protection is offered. And that is something that we need to see when we test these cases in court. So, yeah.
Yeah, see. Ms. Anouilh, over to you. Your closing remarks, please.
Hello. Yes. Is it my turn?
Yes.
Yes, sorry. No, I just want to rebound on the debate. You know, the High Authority for Transparency in Public Life in France was created after a major scandal involving Jérôme Cahuzac. He was the Minister of Budget at the time in 2012, and he didn't want to declare a fund abroad, and he lied in front of the National Assembly several times before confessing that he had account abroad. And after this case, the High Authority for Transparency in Public Life was created in 2013. And since then, since 10 years, we saw that the trust between citizens and public officials have really improved because we put in place the declaration of assets, the declaration of interest, and because also among members of parliament, they know that they cannot get away with the legislation and their binding obligation. So I think, you know, you can see improvement if you put in place very binding legislation. And also regarding education, our president and also I and other colleagues, we do trainings abroad. We do trainings among school, among university, and we collaborate with other agencies. We do expertise mission also in order to train other agencies on declaration of assets and interest. So I think this is very important also.
Thank you for that. Thank you.
Thank you.
Do you have any questions? Right?
Hello, I'm Andreas Papandreou. I'm a Cyprus citizen, proud citizen, but I'm very ashamed of my country in accordance with what the politicians and the people governing this country have done. And I'm here to raise a question that most of the people in Cyprus have. I'm speaking directly, mostly to you as an MP, that you can actually do something. Most people in Cyprus don't trust the institutions, the authorities to do their jobs, because provenly the system is built in a way that the institutions don't have the power to do something. And that the simple mind of a Cypriot does not allow him to understand that you as a person holding this position cannot take justice. The former president, for example, most people have problems with him. And the problem starts why should I trust the Attorney General was so many times proven that he is not willing to take any corruption cases to the court to do something with your authority, for example. And why did you as an MP, as Parliament as a whole, allow again for the same system to run the prosecution? I get it's a constitution, it's all of this stuff, but how many times did we trespass the constitution in accordance to avoid people going to jail? Why not doing it?
As an MP, I don't have any power.
I'm not speaking
No.
to you as an
I mean the Parliament, you know, in which way the Parliament exercises control over the other institutions is through 3-4 measures. One measure is to file a question. I have to tell you that this morning I was dealing with my questions, and I have questions that I sent in 2021 and still they are not answered by the relevant ministry. Okay, and if they are not answered, my second choice is to file what we call afterbanghelto. So we can file the issue to be debated in the committee, and it has to wait for I don't know how many months or years sometime. The third is to file a law proposal to change a law. I filed the law proposals on this issue. The division of the powers of the Attorney General to empower the authority with interrogation powers. It's there. It's in the committee. The president of the committee will decide to put it or not on the agenda. And I'm still waiting. So what I am saying is that unless there is the political will by all parties and by the executive, which means the president, we cannot really, and we need speed, because corruption now is institutionalized. And I will explain why. In Cyprus, the executive powers are in the ministerial council. It's not with the president, it's the ministerial council that decides, but the president appoints them, dismisses them. So we know what happens. But the ministerial council has the power to bypass laws. And I am saying environmental law. So it's like institutionalizing corruption. Those who have access to power, those who have money, those who can really go behind the scenes, they have the power, and they get what we say, it's halarosis. I mean, the law is not applied, and we've seen a lot of corruption, especially with the environment, because we have a very strong developing construction industry, and we see a lot of corruption. Nothing is happening. They come, they sit in front of us. We had a case yesterday, and they are greenwashing everybody.
That people don't blame you because you are an MP. They think, I know this is not but people blame you as a parliament because you don't do something. Because once again, you legislated one institution that actually has no power.
Yeah. But the people don't know the powers, so they put us all in the same. That's a problem.
Don't know
yes.
if the commissioners want to comment on that or, you're right? Yeah? Okay. Next question. Yeah.
Regarding independent authority against corruption, it's true that, Alexandra, we had worked during the preparation of the legislation for the formation of the new authority, and it was a big resistance and a big discussion over the issue whether to give to the authority to prepare the criminal case, εξουσίες ποινικού ανακριτή, not to prosecute. It's the Attorney General's job to prosecute, but to prepare the criminal file. This has not been given to the authority, and it's really a pity. And even the Parliament agreed not giving the authority.
You remember what happened?
Yes.
Very well.
So, and then we said, okay, so be it. Let's have the independent authority. It should start. Let's not pause anymore, and we can do something to fix it later. But the question is, did we have a case where, oh my God, if the authority had this authorization, this εξουσίες ποινικού ανακριτή, if they had it, they would have done something which did not happen because of the lack of this authorization? So far, we have not seen. We have not seen a case where the independent authority against corruption, if it had the authority, something would happen, and because of this, it didn't happen. So we're waiting for you, and this is something where the people are waiting from the authority to have such a case. So far, no.
We have undergoing investigations on many very big cases, which last for months. And some cases, we finish them on our own or through very short investigations. Until now, we didn't have. But the big investigations will show if they have results in some weeks or months. I cannot say anything else, but probably you're in a hurry to see because this...
Yes, but you should have, I think you should be lobbying. Sorry, I'm a bit...
Yes.
How would you be lobbying in a way that's impressive? Going out in the central square and shouting, give me this authority.
Okay. To do that, okay, it's good, but we managed to set up a good working program in our authority. If we change that now, you have to change all the things in the authority. That means you have to change the investigators. Now we have investigators, then we have criminal investigators. We have to train them. We have to, which means another 3 or 4 months to stop our work and then start again from... Yes, okay. If Parliament gives this power, we'll do it. But at the moment, our effort is to get permanent staff so that we can do our job, because we only have one person who is a permanent employee in the authority, only one. All the others, the lawyers are with a 1-year contract. Budget we have.
They have budget. We gave them
Staff resource.
Budget,
human
we
resources.
asked, we got all we asked about budget, but we don't have permanent personnel.
Human
Our
resources.
lawyers are 1-year contract, which means when the year
Which
finishes,
means that the government does not mean it. Because when you have a higher authority, I'm sorry, Commissioner, but when you have a higher authority, you empower it with the powers that it needs, you give them the budget, and you give them the personnel, and it has to be permanent personnel, because you are training them, and then what? You are going to lose the competence. So if we mean it, it means that we have to empower the Commission, and the Commission has to be consistent on enforcement, it has to be independent from political influence, it has to acquire the public support, we need the public support, and all of this will foster a culture of trust and the culture and when people trust you, you can demand more. When people don't trust you, you don't demand, they are not in favor. This is what I mean. I mean that I am ready to fight for the permanent personnel. I am ready to fight for the budget. I am ready to fight for empowering with interrogation powers. I am ready, but the Commission has to be at the front.
Okay, thank you. Thank you. Yeah.
Sorry. Yeah, my name is Fabian. I'm a professor for property law in Frankfurt.
Sorry, I can't hear. Yeah.
Can you stand up, maybe? Can you stand up, please?
Thank you.
Thank you. We have a question to data protection and transparency. We try to implement a transparency register in Germany, and we fail miserably because of data protection. And landowners misunderstand the principle of data protection. They think their right of protecting and dispose of their own data is a property right deriving from their property right, which is a phantom.
Yes.
And it's my very interesting discussion. And we failed since 20 years to implement a movable property register. You know why? The institutions are not connected. And I have a question maybe to you. Is there a court decision in Cyprus about the data protection right of a landowner? Because in my country, in Germany, we have the corruption is construction and land. This is we estimate the black money of corruption is 300 billion per year. And everybody knows this, but we cannot act anything against that because property right is protected. So maybe it's a question to you. Is there a transparency register calling assets declaration in Cyprus? Is there discussion going on also that the landowner and the ultimate beneficial owners have to register their properties?
Yes.
As oligarchs,
we have land registry in Cyprus.
Okay,
land registry.
Land registry.
And is there a decision by the Constitutional Court that says landowners their data protection is derived from the property?
Yes, but they can have access. Whoever has legal obligation to have. We have an article in the relevant law. It's 51A that says when you have a legal obligation, you can apply and you can get data and information about the land of another person. So based on the legal obligation, you can have access to those data that does not belong to you.
But the Ministry of Interior or Commerce in Cyprus, they don't have a transparency register.
Me?
So they can have an overview who's on Cyprus land, for example.
The land registry is under Ministry of Interior. It's a department of Ministry of Interior.
Thank you. The gentleman there, yeah, thank you.
Question for the Data Protection Commission. It's about the right to access information law that was passed, I think, in December 2021.
2020. Effective
came into force.
Yeah. Came into force.
I'm hearing a lot of anecdotal reports about people trying out the law and seeing that it's very easy for people to refuse the information. And my understanding is that your office has been the de facto receiver of every case that needs to be decided. And I just wanted to have your take when it comes to, is indeed either the implementation of the contents of the law weak and don't really force people to relinquish information in cases that they really don't have a good excuse to do that? Is there any room for improvement there?
No, I think it's not the provisions of the law that are not strict. It's a matter of awareness. That's why we're trying to make awareness of this new legislation, because it's a national registration, 3-year-old registration. December will be 4. And you are right that the public authorities in Cyprus refuse to even respond to the applicant. But when and whenever we intervene, they give the information. That's the important thing. But you are right, we have to be more extrovert maybe in order to create more and more awareness of this legislation. Lately we have prepared video, and we showed some videos and spots on the radio for this legislation, but there are steps, I mean, we can strengthen this trial.
Thank you. Yeah. Yeah.
I don't have a question. It's just an information I'd like to give you, because you were talking before about the whistleblowing issues that you have and issues with retaliation. So through my work, I discovered that there is a public website called Global Leaks, and a person can do an anonymous whistleblowing report, and an investigation can begin. And then that person can also be informed of on the status of the case at each point of the case of the whistleblowing investigation. So that ensures the anonymity of the person who reports the whistleblowing incident and the corruption incident. So maybe that's something you'd like to investigate, because there are also anonymous whistleblowing reports, but through this public website, everybody can go in and perform a complaint, a whistleblowing report. So I just wanted to inform you, so maybe you can use it in your day-to-day work and we avoid issues of retaliation.
Thank you so much. Yeah.
Can I add something on this? I sent a letter asking about what the public sector and the private companies have done to establish what we call corridors of and a structure for whistleblowers. Channels. So some of them, they didn't even know about this. So the law is there, but how it is applied, either by the government sector or the wider government sector or the private companies, nobody can give me a solid answer. So we have laws about everything in Cyprus, and actually, if you see the rule of law report of the Commission, they always say that our laws, we have improved. In Cyprus, what is our problem is the enforcement of the law. That is the problem.
Thank you. We've got a final question. Yeah, thank you.
Whistleblower.
Thank you. It's actually a remark. I'm Christina Karakosta from the European Commission, the Rule of Law Unit. And I would just like to say that the issue of resources of the Anti-Corruption Authority is an issue of recommendation that we have addressed to Cyprus since 2023-22. And we have asked Cyprus to actually continue the efforts and give the resources, because the resources is not something that needs to be ignored. It's very important. Because you may end up having even more powers, but if you have nobody to actually use these powers, then at the end we arrive at the same outcome. Thank you.
Thank you, Christina. Yeah. I think you agree with me. We had a very diverse discussion with a very diverse group, and I'd like to join me to thank the members of the panel.
Thank you.
Thank you.